All right, let's dive into a fascinating and frankly intense corner of the law. We're talking about Article 160, what I like to call the double down rule, and it's designed to answer one very specific, very high stakes question. So picture this. What happens when someone commits a crime while they're already serving a sentence for a previous crime? This isn't just about being a repeat offender. This is about defying the system while you are actively under its authority. It's kind of like a poker player losing a hand, being forced to sit out, and then trying to steal chips from the pot while sitting in the penalty corner. So, what does the law do? Does it just add another penalty on top of the first one? Or does the entire game change? Well, the answer is the game absolutely changes. This isn't a loophole or some overlooked scenario. The justice system has a very specific, very deliberate playbook for this exact situation. It's a rule that basically says, oh, so you see our penalty and you raise us another crime? You decided to double down on your bet against the house? Well, guess what? The house is doubling down on you. Okay, let's get into it. Section 1, the law's double down rule. We're going to unpack exactly what Article 160 is and what makes it tick. So, at its very core, Article 160 is what's called a penalty enhancement, and this is a really important distinction. It's not a new, separate crime you get charged with. Think of it more like an amplifier. It takes the penalty for that new crime you just committed and cranks the volume all the way to the max. It's a special condition that only gets triggered if you commit that new felony while the justice system is already dealing with you for a previous one. So, for this rule to kick in, a few key things have to be in place. I like to think of it in terms of a game. To understand the rule, you have to understand the three essential components: the player, the move, and the mindset. It really does break down this cleanly. You've got to have the right person making the right kind of bad move with the right or, well, wrong state of mind. Let's look at each piece of this puzzle one by one. First up, the player. This rule doesn't apply to just anyone. It's specifically for a convict who is under what the law calls final judgment. Now, what does that mean? It means the whole legal battle for that first crime is over, done, finito. The trial has concluded, all the appeals have been heard and denied, or the time to file them has expired. The verdict is no longer a maybe. It's a certainty, officially locked in the books. Only then does the person become the player in this particular scenario. Next, let's talk about the move. The action that triggers Article 160 has to be serious. We're talking about a new felony. This isn't for minor stuff like a traffic violation or a small misdemeanor. The law reserves this heavy-duty response for a significant, serious new crime. It's a recognition that the person didn't just stumble, they committed another major offense, showing a profound disregard for the law they were already being punished for breaking. And finally, perhaps most importantly, we have the mindset. The new felony can't have been an accident. There must be what lawyers call mens rea, literally, a guilty mind. This means the person had to have intended to commit the new crime. It was a conscious choice. This element is absolutely crucial because Article 160 is aimed squarely at the offender's deliberate defiance of the legal system's authority. It's the conscious decision to break the rules again that the law finds so egregious. All right, Section 3, let's talk about the key that starts this whole engine. We mentioned that term, final judgment, and I can't stress this enough. It is the single most important prerequisite. When it comes to Article 160, timing is literally everything. You see, getting convicted by a court is just the first step. After that, there's usually a whole process of appeals that can go on for a while. But eventually, you get to a point where either all the appeals have been used up and failed, or the window to make an appeal has closed for good. That moment, that's final judgment. It's the legal point of no return. The gavel has fallen for the last time, the ink is dry, and the verdict is set in stone. It is only after this point is reached that the clock for Article 160 starts ticking. So this rule is triggered in two specific windows of time, but notice that both of them are after that final judgment. The first is a little strange. It's if you commit a felony after your judgment is final, but before you've actually started serving your time. Maybe you're out on bail waiting to be transferred. The second is more straightforward. It applies if you commit a new felony at any point while you are actively serving your sentence. In either case, the law sees it as a direct and blatant challenge to the court's authority. Okay, Section 4. We've set the stage, we know who the player is and what move they made. So, what's the actual consequence? What happens when you up the ante like this? Well, this is where Article 160 really shows its teeth. The penalty is the maximum, period. Full stop. Let me explain why that's such a big deal. Normally, when a crime has a sentencing range, say 10 to 20 years, a judge has discretion. They can listen to the arguments, weigh the facts, and decide on a sentence somewhere within that range. But when Article 160 is applied, that judicial discretion vanishes. It's gone. The law basically puts on a blindfold and points to one number, the absolute highest possible sentence for that new crime. Just look at this table. It makes it crystal clear how mechanical and automatic this rule is. If the new felony carries a penalty of, say, 6 to 12 years, the sentence isn't 7 or 9 or 10, it's 12. End of story. If the range is 10 to 20 years, it's 20 years. There's no debate. It's a rigid, uncompromising, and incredibly severe formula. Now you might be thinking, is anything else considered? And the answer is yes, but maybe not in the way you'd expect. The court does still look at other factors, things that make the situation worse, called aggravating circumstances, like being a habitual criminal, and things that might lessen the offender's culpability, called mitigating circumstances, like good conduct. But here's the catch. These don't change that automatic maximum sentence. Instead, they can influence other things down the road, like eligibility for parole or how different sentences are served. So we've established that this rule is incredibly harsh and automatic, which naturally leads to the next question. Is there any way out? Are there any exit strategies? Well, as we'll see in Section 5, there are a couple of potential defenses, and one very, very conditional mercy rule. The main defenses are all about challenging whether the core ingredients for Article 160 were actually present. A defense lawyer's first move would be to attack the timing. They might argue that the prior conviction wasn't truly under final judgment yet, maybe an appeal was still technically possible. If they can prove that, the rule doesn't apply. The second major defense is to attack the mindset, arguing that the new felony wasn't actually intentional, that it lacked the required mens rea.
But beyond those defenses, there's another path, a very specific one, and it starts with this number, 70. This isn't just a random age. In this context, it signals one final long-shot possibility for relief.
And that brings us to the ultimate question. After a rule this strict, is there any room for mercy in the system? The answer is a very qualified yes. It's not a right, it's not a guarantee, it is a conditional pardon, a final possible chance for clemency. But look at how strict the conditions are. It's like an escape hatch with 4 different locks on it. First, the offender has to live to be 70 years old. Second, they must have already completely served the sentence for their original crime. Third, they have to be deemed worthy of this clemency by the authorities, which is a subjective judgment. And the final massive lock, this option is completely off the table for anyone classified as a habitual criminal. It's an incredibly narrow path. So when you step back and look at the whole picture, it becomes clear that Article 160 is more than just a tool for extra punishment. It's a defensive measure. It's a powerful statement from the justice system itself. The message it sends is unmistakable. A court's final judgment is absolute, and any attempt to defy that authority will be met with a response that is swift, severe, and automatic. And that really leaves us with a big question to think about. Is this double-down rule a necessary shield that protects the integrity and authority of our entire justice system? Or, with its rigid and automatic penalty, does it become an unbreakable chain for the offender, removing any real chance for nuance, discretion, or rehabilitation? It's a powerful legal tool, and that tension between protecting the system and judging the individual is definitely worth pondering.